What we were doing was we were enabling Aboriginal communities through their leaders at that grassroots level that came in as the field officers to have a base or an office or an institution from which to confront the criminal justice system. My name's Eddie Neumann. My full name's Edward Solomon Neumann, known as Eddie Neumann. And I was the foundation secretary of the Aboriginal Legal Service in New South Wales. How I first got involved is I think is quite informative of how the service grew, and that is that I was a law student at the time, and I mean, these were sort of turbulent times in terms of what was happening not only in Australia, but what was happening in Europe, in France, in Czechoslovakia, really with student demonstrations and protests against what was wrong in those societies. And in Australia, there was similar. There were the starts of campaigns on policies that were seen to be morally wrong. I was in the fortunate position that, unlike most of my peers at the law school, I wasn't employed as an article clerk as well, but instead I had a position as a part-time tutor in the Department of Government or Political Science at Sydney. And it was in the course of one of my tutorials that one of my students said to me that, and it was simply in these terms, that there was a group who were going to meet in Redfern, I think the following Thursday, and they wanted to see what could be done about police harassment of Aboriginal people outside the Aboriginal hotels in Redfern on Thursday, Friday and Saturday nights, and would I like to attend the meeting? Now the person that asked me was somebody who'd been involved in an organisation called ABSCOL. So I went along to the meeting, and at the meeting I met for the first time Paul Coe and I think Gary Williams, and I can't remember whether Gary Foley was at that meeting as well. It might have been later on, and we were told about what the situation was, and the situation basically was that it was open slather for police to come to the hotels and just arrest people whether they were breaking the law or not breaking the law, and cart them off. And what was said to us was that this was at the time the infamous 21 Division, which was a detective training division, and they had the right to go anywhere and basically go into the hotel and arrest whoever they wanted to arrest, and it was all sort of a bit of a training exercise. So we thought in terms of what can we do about that, and we decided that first of all we decided we'd have more meetings, we'd bring in more people to see what we could do about it. And one of the ideas was that there was a lack of witnesses who could say with objectivity and whose evidence couldn't be readily impugned as to what actually occurred, and that a way to proceed might be to get what we were calling VIPs to be outside the hotels and observe what was going on. So these were the sorts of ideas, but we decided that we needed to have people with more status and power than the ones that we had at the meeting, with the exception of Ken Horler, and so we were all going to sort of see what we could do about that. A friend of mine who at law school who was also a part-time journalist had recently interviewed Hal Wooten, who was then to be the dean of the new law school that was being established at University of New South Wales, and I talked to my friend, his name was John Carrick, about that, and he said, well, why don't you speak to Hal Wootton? So I then, maybe being a bit more brash in those days, I rang up Hal Wootton sort of cold and said, look, this is what's going on, would you be interested in coming along to the next meeting and getting involved in this? We thought it might be something that the new law school could get involved in. And Hal was very receptive, and he came along to the next meeting and to further meetings and brought other people along to the meetings, and out of that the Aboriginal Legal Service Council became established, and the Aboriginal Legal Service Council was composed of VIP people such as leading QCs, professors at the University of New South Wales and the University of Sydney. It had older activists amongst Aboriginal people, and then it also had the younger activists, or if I could use the term, the Young Turks. So it became a forum where young radicals could sit and talk with persons who were had power and prestige in society, and could also talk and put their viewpoint to the older Aboriginal activists who'd been particularly involved in the 1967 referendum, because what the younger activists perceived was that the referendum had come and gone and there'd been absolutely no change to their situation. Aboriginal people were still getting their heads kicked in, there was no change, there was no recognition of their rights. What the Aboriginal Legal Service then was set up to do was to see what could be done to ensure that that there was recognition of Aboriginal rights and Aboriginal people as people and as citizens by the legal system that was meant to protect them. What we were able to institute was to have VIPs who would be outside the hotels and could observe what was going on, and who could provide a report which couldn't be impugned on the basis, oh, they're just blacks, or they're just student radicals. I was there on one occasion when a senior QC who was on our council, who later became a judge, he's passed away now, Ernie Noblanche, interceded when he saw some police arresting an older Aboriginal woman who was obviously not affected by alcohol and was not breaking law in any way, only to be sort of rudely told by the young police officers that were doing that if he didn't watch out he'd be arrested as well, at which stage he stated his name, Ernie Noblanche QC, which was heard by one of the older officers there, and immediately recognised him, and then came in and interceded and stopped the police officers from arresting him himself. But it was instances like that where people who previously had no very limited experience with what Aboriginals had to experience each day of their lives saw the reality of the situation and became impassioned advocates for a change to the situation. The Aboriginal Legal Service initially existed on sort of volunteer labour, if I could use that term, or volunteers, and also on donations. The chairman of our management committee, Ross McKenna, who was in the French department, he'd organised academics to be donating money and put the challenge out to the lawyers that got involved to start donating money. And so we started to build up a small amount of money which we wanted to use to establish an office, and we were able to establish an office which was initially based at the University of New South Wales Law School. I mean, the model was that there would be a legal office, so that there'd need to be a lawyer, but the crucial role in this new Aboriginal legal office that we wanted to set up was the Aboriginal field officer. And we were lucky at that time that there were a number of people in different key trouble centres around the state who, in effect, all of whom had criminal records, and my experience then was that there weren't too many older Aboriginals who identified as Aboriginals who didn't have a criminal record. And so, but the point of it was that they knew what the legal system was about and how it operated, and they, rather than the solicitor, were seen as the key member of the office. So maybe not the boss of the office as such, but they weren't just somebody who would sort of carry the books or go and pick people up and bring them into an interview. They were involved in how cases were run and how policy was developed. So the strength of the Aboriginal Legal Service was that it had these grassroots heroes, if I could use that word, who were respected by Aboriginal people in the areas, being fighters for Aboriginal people, who were involved in the offices, and in a sense what we were doing was we were enabling Aboriginal communities through their leaders at that grassroots level that came in as the field officers to have a base or an office or an institution from which to confront the criminal justice system. And not that we were on an equal footing, but at least confront it. At that time we had a large panel of lawyers who'd volunteered services, and that panel was used quite extensively. And this was it was the first, New South Wales was the first Aboriginal Legal Service office to be set up, and it remained on sort of a limited basis in terms of how many officers we had and what we could do, until the sort of I think it was the last year of the Neumann Prime Ministership, when Billy Wentworth, who was the Minister for Aboriginal Affairs, made contact with us, and it took us all by surprise at the time, and said that the government was willing to provide some funding to set up a couple of offices. And there had been a number of strategies that the Aboriginal Legal Service in New South Wales had developed, and I mean, one of those was that was to get over the problem of bail. That was one of the sort of first issues that we had to confront, and that arose this way: that the way the system worked, if you wanted to defend a charge because you were innocent of that charge, of course you'd plead guilty, but then the case wouldn't be dealt with when you entered your plea of not guilty. The case would then be set down for a hearing at some stage. And then the issue would become, well, what would happen to you in the meantime? And invariably, you would be refused bail, because Aboriginal people would go on walkabout, and they mightn't have a fixed place of address, or they mightn't have a bank account, didn't have a job, were considered not to have connections, and so you would be locked up. So it might be that you were locked up for 2 or 3 months to fight a matter which you might end up losing, and all that would happen as a result of that would be that there would be a fine. People just worked that out and said, well, we'll get off pleading guilty. Plead guilty and we'll sort of get out quicker and less to deal with, without realising that what that meant, of course, that you had a record, and so it would become worse next time that you had any, and your credibility would be much less next time you had an interaction with the criminal justice system. And eventually, the pressure that was on led to a change in the way a bail was given in New South Wales. So what started to happen was that advances in, if I could use that word, in criminal law were really as a result of this new body that had been established, the Aboriginal Legal Service, to defend the rights of those who got the worst deal under the criminal justice system, and that sort of then filtered through to give benefits across the board. So the strength of the Aboriginal Legal Service was that it had these grassroots heroes, if I could use that word, who were respected by Aboriginal people in the areas, being fighters for Aboriginal people, who were involved in the offices, and in a sense what we were doing was we were enabling Aboriginal communities through their leaders at that grassroots level that came in as the field officers to have a base or an office or an institution from which to confront the criminal justice system. And not that we were on an equal footing, but at least confront it.